Welcome everybody. Ethics and IP is a subject which, roughly speaking, consists of people who think they know about ethics trying to interfere with IP. We have a super expert panel, and I have taken the opportunity of plugging my own book. Christmas is coming. After we go across to the cloisters, I don't know whether it's north or south, for some drinks, all mobile phones will now please be off. We have places for people who leave them on. I don't propose to say much about any of our speakers. They're all top class. Some of you may have heard Pete Coffey. He's actually been doing things which have been contrary to human dignity for a number of years. And he's going to be more precise about it. Aurora Plomer has written about this subject extensively. The focus is going to be mainly patents, but not only. Henry Carr is going to sweep up on patents and say what he thinks about what's been going on. And then Lionel Bentley is going to do the rest of IP, a bit like the reduced Shakespeare Company. So let's kick off. Pete, will you start?
Okay, thanks very much. Thanks for this evening. And this is, as it says, part two of a discussion which we had when this issue first arose, which was a decision which was made by the European Court of Justice on patents and whether it was actually something which should be patented. So I'm just going to bring you a bit of the science, and basically it's around the use of human embryonic stem cells in which that challenge was made. So I just want to bring a bit of education to the part of the evening. Not that the rest won't, but just to actually go through some of the issues which some of you may or may not know. So the whole issue around stem cells came from the work which led to the Nobel Prize for Evans here in the UK, which was the ability to produce what were called stem cell lines. And typically, prior to this, they were found in adult tissue, but weren't able to be produced or replicated or used in a way which could help therapeutic possibilities within medicine and disease, or for certain diseases. But in 1998, Jamie Thomson discovered that actually it was a group of cells in what is called a blastocyst. Now, a blastocyst is a fertilized egg. So the egg, the sperm come together, 5 days later, you get a blastocyst. And it's this collection of cells, the inner cell mass, which produces, or what, as a scientist, we use as an embryonic stem cell line. Why are we actually doing that will become evident very soon. But this is how big that is. It's cells. It's not a formed fetus. So these terms which people band and throw out do have very specific meanings within biomedicine, but are often interchanged and used quite wrongly in terms of presenting other people's cases. So this picture here is what a 5-day-old fertilized egg is, and this is the group of cells called the inner cell mass. And that is what this whole debate was about. It's the ability to use those cells, the inner cell mass, to produce the embryonic stem cell line. So at 5 days, that mass of cells then goes through another process to be made into a stem cell line. So it's never been in a woman's uterus, it's never been placed there, it's all done outside in a dish over a 5-day period, and then that inner cell mass is taken and then actually produced into what is called a cell line. That cell line has two abilities. Why it's called a stem cell. It can do one of two things. it can actually turn back into itself, so produce more stem cells, or it can decide to produce a daughter cell and a cell which would develop into any other cell in our bodies, of which, there's 200 plus different cell types. So that's what a stem cell does, and that's what we're trying to harness. We're trying to harness both of those. We're trying to make sure we keep making more, which means we never ever have to go back to that blastocyst again. It will infinitely keep dividing. And an example of that is my own work, in which we have a stem cell bank just from one blastocyst in Scotland, in London, and in the US, which could potentially serve a clinical population I'm interested in of about 30 million people. So that's it, one blastocyst to produce potentially a therapeutic for 30 million people. But the major reason for my interest is not that I want to produce more stem cells. I've never ever wanted to do that. What I want to produce are cells that could be used for disease. And that's the stage at which these cells become of interest to someone like myself, because those stem cells have the capacity to turn into all the cell types which make our bodies. So they form heart, lung, liver, kidney, and my interest is in the eyes. So I can produce eye cells from these. So from a 5-day blastocyst to this stage allows us then to produce many different cell types which could be used therapeutically. And that ability is called pluripotency. Now, pluripotency means it can produce many, many different types, but it can't produce every single type of cell type. That's called totipotent. And totipotent, to make this distinction, we have to because of some of the legal issues which have been brought up. Totipotent would mean it would be able to produce every single cell, including the egg itself, which embryonic stem cells can't. They can't produce what's called the trophectoderm, so the actual egg itself. So they're not totipotent, but they're pluripotent. Okay. In this whole issue, the way in which those cells are produced, the way they then make the cell lines, and the way they are then made into cells which would be relevant for disease, all contains the possible ability to produce IP. Either in the process of making the stem cells or making those stem cells into eye cells, there's a whole gamut and possibility for which we were allowed to, prior to this decision, to produce IP, and we were expected to do that, both for the research councils who fund us and for Europe who funded us as well. There was an insistence that we needed to protect that knowledge. So, the Brüstle case came when Greenpeace decided to challenge whether IP should be produced from changing a stem cell into, in Oliver Brüssel's case, into a neural cell, into a brain cell. So that process he'd actually put through the process of protecting, but then was actually taken to court. There are many different rules. This is one of the other problems within this whole ruling. Within the European community, some of the states allowed embryonic research and allowed the production of human embryonic stem cell lines. Germany didn't. Neither did Italy. Neither did Portugal. However, they allowed you to import someone else's embryonic stem cell line, which again was at odds. Now, as far as I understood at the time, and I'm not a legal person by any stretch of the imagination, the whole idea of the European justice system was to try and at least some way unify and equalise through what was current with all states. What happened was not that case. What they decided was it wasn't and should not be patentable to actually take any embryo and do anything in terms of using it as a commercial source or to produce therapeutics. And that basis was around a moral question around when is an embryo or when should be an embryo be protected. And there are 4 issues there, as in when do we believe the embryo itself should actually get a moral status. Even at the time, although science advice wasn't asked for, there was in many countries a decision that 14 days, which was when the first central nervous system of the embryo started to develop, should be the cut-off point. That wasn't even decided on. And then this whole idea of, as the embryo develops, do you actually give it more increasing status? And I'm not going to go over what was said at that judgment, but today the big issue was around, has it affected research funding, both in terms of the lack of ability now to perform or put down patents in this area? And the answer is yes, I believe it has. A lot of the work, even though advancement in science has continued avidly along stem cells, and a new area where you can now take skin cells and turn them into a pluripotent cell. The whole area came from embryonic stem cells. So that knowledge and that ability to use that patentable knowledge has been lost in Europe because we can't maintain it, and we now have this new area. Equally, the Commission was sent a petition of about 1,000, I can't remember how many, it's a lot of signatures. They have this case whereby if a petition's put forward, then again the European Parliament has to decide on whether it will rule for or against. And what they were asking is that given Europe didn't allow, under moral grounds, the use of patents for embryonic research, therefore should we use European money for research funding, which was a completely different question. That was overturned just recently, but as I found this evening, actually it's come back on the table, and that's where I'll now change and hand over to the next speaker.
I was the person who produced the report on the specific moral exclusion on embryonic stem cell research in the EU directive. And this was because I led a project which was funded by the European Commission back in 2005, specifically to examine the scope of application of this provision. What we did in that team, I mean, there were some lawyers from Sweden, from the UK, and stem cell scientists who were involved in this, was to, first of all, try and retrace the drafting history of this provision to determine what the legislative intent was. And this wasn't at all straightforward, because the database that is operated by the European Commission is really quite difficult to utilize. But we did find, and retrace all the steps. And what we established is that it was this specific provision was introduced in the late stages of the drafting of the directive, that the UK in particular had a great interest in the way this provision had been worded, not least because at the time, back in 1997, 1998, the UK already had in place the Human Fertilization and Embryology Act, which permitted research on human embryos. So they were very concerned, the UK was very concerned that the effect of this provision should not be to render unpatentable research which was lawful in the UK. And the wording was therefore specifically changed to make it as narrow as possible so that it wouldn't encompass research uses of human embryos which were lawful in the UK. Hence, this rather, kind of strange wording that industrial and commercial uses of human embryos are not patentable. That's what the provision says. It certainly wasn't intended to reach out to any further downstream uses of cell lines or cells obtained from human embryos. But of course, as you know, I'm sure many of you read the Brüstle case, this particular aspect, of how the directive came about was not even considered in the judgment. The judges in the EU court didn't ask themselves what did the legislator intend. Instead, they set out on this ethical search for the meaning of the provision, and they did that as well without taking into account other, in our view, and we mentioned this in the report, and I've talked a lot about this in publications since, other legal anchors and parameters they should have taken into account. For instance, the fact that the question of whether or not research on human embryos should be permitted in the European Union was actually specifically discussed in the European Parliament in the passage of the EU Directive on Human Tissue and Cells. And there were attempts by pro-life groups, particularly and religious groups, to try and outlaw this research in Europe, and they were defeated. They were not successful. So this is all evidenced. There was a specific parliamentary discussion in the European Union of the legal status of the human embryo in the European Union, and it was agreed that there was no consensus and that this research should therefore not be outlawed. And the same happened with the EU regulation on regenerative medicines. So within the EU itself, there was very specific legal directives which had been adopted on the basis of a discussion which evidenced that there was no consensus in Europe on this matter. And then, of course, beyond this, there is beyond the European Union itself, although there is the Council of Europe and the European Convention on Human Rights, which the European Union is meant to respect, and of course all the jurisprudence of the European Court of Human Rights is on the rights of the embryo, and specifically under Article 2, is absolutely to the same effect. It just differs these issues back to member states, specifically precisely because there is no consensus in Europe. And at the time we wrote the report, we even were lucky enough to have the Evans and UK case, which actually, where the European Court of Human Rights had to decide whether or not the request of a UK woman who had separated from her partner, could have an embryo implanted, their joint embryo, when he no longer agreed to. Under the HFE Act, this is not permitted because he has to consent. She then tried to take the matter to the European Court of Human Rights and argue that this was contrary to Article 2, that the frozen embryo had a right to life, and that she should be allowed to have it implanted. And the European Court of Human Rights disagreed and just reiterated its jurisprudence, well-established jurisprudence, to say we are not going to here give a definition of the human embryo and actually give it legal protection under Article 2, because there is no consensus in Europe on the status of the embryo. So this matter is left to member states. The European Union Court actually knew all this. They had our report, they had the book, that we published, which specifically also addressed all these issues, and they spectacularly ignored it. And that's the dubious kind of, claim to fame I have here today. That, that the contribution I made to this field has been spectacularly ignored by the court. There you are. But I haven't changed my mind, and I still think, and I've written quite a bit about it since. I actually feared at the time, and I worried, that if the exclusion was to be interpreted broadly, and I didn't certainly anticipate it was going to be interpreted as broadly as the European Union Court decided to, that it would actually impact on research. Because it seemed to me that the real target of this provision was the research. It's not the patents. And you can't actually apply a principle here to interpret this provision, which states that the patents on uses of human embryos may not be allowed on moral grounds where there is a destruction of the human embryo on the grounds that this is contrary to human dignity, and at the same time have a situation where, in fact, in a majority of member states in the European Union now, precisely this type of practice is lawful. 18 out of 28 European states, member states of the European Union, have adopted legislation which is permissive of destructive research on human embryos. That's where we are today. That is the reality. And actually only 6 have got laws prohibiting the research. The rest don't even have any legislation in place. So it seemed to me that if the European Union Court went down the route of interpreting this provision broadly, what it would do was to create a systemic conflict in the European Union system, whereby the regulatory framework for research is devolved, and the ethics of such research is devolved to member states. That's accepted. So they still retain sovereignty in these matters. There is a majority of laws which are permissive of this research, and yet we're being told that the patents are not permissible on moral ground, on precisely the same ground on which the research is permitted. So where do we go from here? Now, one of the concerns, and sadly, I was proved absolutely right, that this would actually be used as, as a prop by those who are opposed to the research to then try and push for a ban on the research and for a ban on the funding of the research. And that's indeed what's happened. So as soon as the EU court issued its judgment in Brüstle, the pro-life groups in the European Union began to campaign to stop the funding of embryonic stem cell research in Horizon 2020. And I can tell you, because I was quite involved in looking at the various amendments to the Horizon 2020 is the program which the European Union now uses. Before it was called Framework 7 and Framework 6, etc. Horizon 2020 is the program to fund scientific research across the European Union. So the opponents of stem cell research, embryonic stem cell research, immediately used the Brüstle ruling as a reason to campaign for the ban on the funding of embryonic stem cell research in Horizon 2020. They were only narrowly defeated, but they were defeated, However, that wasn't the end of the story, because they then created this pressure group called One of Us, which has got a tiny cell at one end and then, scaling up into a human being, which set out to gather signatures across the European Union so that they could then put a petition to the Commission under a new provision in the Lisbon Treaty, which would then, whereby the Commission would be asked to look at some proposals, new legislative proposals. So they set out to gather, and they did successfully gather 1.7 million signatures in a petition which asked for the funding of stem cell research to be stopped. The petition specifically mentions the Brüstle case. And part of the petition also asks for the EU to stop funding the support of abortion services abroad in developing countries. That petition went to the Commission. The Commission had to reply within 3 months. It did reply, and it said, we're not going to revisit this issue. There has been a legislative process only recently whereby the European Parliament and the Council, all the various organs together looked at the question of the funding of embryonic stem cell research, and the outcome was Horizon 2020, that this funding is actually permitted. So we're not reopening this matter. Whereupon One of Us decided they were not going to agree to let things go. They've now put in a referral to the Court of Justice of the European Union asking for the Commission's reply to be annulled. And we don't know what's going to happen. This is a fairly, recent development. But actually, just to say very quickly that clearly, there are some people, and I understand this because in liberal societies we have a plurality of perspectives, and there are some people who feel very strongly about this, research. However, my own view on this is that these issues relating to the ethics of these are issues which relate to the ethics of the research. In democratic societies, the ethical parameters of this research should go through the legislative process, if anything, because these are issues on which there is genuine moral disagreement. Within the UK, outside the UK, people disagree about these matters. So they are complex matters. They are matters which require, really, ideally, to be dealt with through the legislative process. They are matters for regulators, and they're certainly not matters for the Patent Office, to engage with. They are not, the type of entity which is geared to addressing these issues in a sensible and kind of broad enough way. They do not have the legal expertise, they do not have the democratic legitimacy to begin to seriously look into these matters. So my kind of view is not that there aren't any ethical issues here. Yes, indeed, there are ethical issues relating to the use of embryos or the use of genetically modified organisms or genetically modified animals. Of course there are ethical issues. I mean, I taught ethics before I went over to law, so I'm well aware that, there are many ethical debates here. But the forum in which those debates, I think, should take place is out here in society, and they should be, set in a way that is genuinely involves, a process through which people can deliberate these matters and come to a decision. The Patent Office and patent laws are definitely not, the appropriate forum.
Well, there, thank you, Aurora. So the poison of Brüstle is now being used to try and stop European funding of research into things of the kind that Pete does. He's managed to find a bit of patentability on substrates and things. But it is a threat to European future. Some of us see anyway. Henry, you sent the case off to the Court of Justice after Brüssel. I mean, you might call it Brüssel 2, but it's not called Brüssel 2. Tell us all about it.
Well, indeed, yes, I referred the international stem cell case back to the CJEU, effectively suggesting that they should admit that they made a terrible cock-up in Brüssel, not expecting that they would say that, but thinking it was the right thing to do. I did so when I was a deputy judge, and just to put it into perspective, as a deputy High Court judge, in judicial terms, you are at the bottom of the food chain. So normally you hear cases about litigants in person. In my case, I don't wish to be pejorative, but crazy inventors who've been refused an application by the Patent Office coming along. I remember, I think, the previous occasion I'd sat as a deputy, a gentleman came along to say the Patent Office had been very wrong to refuse his patent for a discovery that gravity didn't exist and that we were held to Earth by a conjunction between Venus and Mars. And indeed, he began his complaint by saying that his wife thought he was a mass murderer. I don't think that was a good start. But anyway, this was rather different. In fact, I remember chatting to a good friend of mine who is a full-time judge and saying, so what are you doing this morning? He said, I'm doing a case management conference in a mobile phone case, essentially about which of the 35 patents should come first and, dates that are convenient for the barristers. What are you doing? So I said, well, I'm deciding what is a human embryo, actually. And I could see him thinking this will never happen again. Anyway, as those of you who know the case will be aware, the issue with Brüstle, particularly the case I had concerned parthenotes. And the hearing officer had found that parthenotes, as is correct, are pluripotent, so they could not lead to human life. They couldn't do it without some form of further intervention that would turn them into totipotent cells. It seemed to me when I read Brüstle, and certainly the Bundesgerichtshof interpretation of Brüstle, that what they were trying to say was that pluripotent cells should be patentable, whereas totipotent cells should be excluded. But they had quite clearly and unequivocally said parthenotes, which is what we were dealing with, are not patentable. Now, you could say, well, because of the vagueness of the language, where they said that a cell is not patentable if it is capable of commencing the process that leads to human life, that they meant what they said. But that would then exclude almost anything that could be the subject of stem cell research from the scope of patentability. Or they could have just got it wrong. I expressed the preliminary view that parthenotes, and in fact pluripotent cells in general, should be patentable, and sent it back. I was told afterwards by one of the barristers involved that it emerged during the hearing that the whole reason in Brüstle, where they had said that parthenotes were not patentable, is because the observations have been mistranslated. So it was that much of a cocker. What they say, if you look at the judgment, is they're not going to come out and say, we got it terribly wrong. But what they say is, when we heard Brüstle, the observations clearly indicated that parthenotes could lead inherently to the creation of human life, and that's why we said what we said. Now we hear that they can't, so they can be, they quite say they can be patented. It's a matter for the national court if they can be patented or not.
Blame somebody else.
Blame somebody else, exactly, yeah, yes. Now, that's where we've got to. So, if you like, international stem cell is a significant retrenchment from Brüstle. I read, I Googled international stem cell to see if any articles have been written about it, and in fact there is an article in the Nordic Intellectual Property Law Review, which I'm sure all of you read regularly. It's actually quite good, by one of the authors is Timo Minsen, who I think Lionel knows. He raises a number of questions following Brüstle, following the judgment in international stem cells. The first question he raised, I think, has been answered. He says, will the European Patent Office follow international stem cell because they're not bound by either the Biotech Directive or what the CJU says? In fact, I understand from Aurora that I would have assumed they would, and I understand that they have now said formally that they are going to. The second point he raises is I think, a much more serious one, which is, if you look at the opinion of the Advocate General in Brüstle, in international stem cell, he says, of course, whatever is said about Article 6.2 and the meaning of human embryo, it is still open to member states to exclude patentability for effectively whatever type of cells they wish, on the basis that their patentability would be contrary to the more general exclusion, namely contrary to public morality and order, whatever it is. That, I think, is a very serious point, because if those states that opposed patentability of parthenotes in international stem cells, such as Portugal and Spain, decide, well, we don't want this, then even though the concept of human embryo is a community-wide concept, it leaves the possibility open that they may say, well, whatever you say, we're not going to allow it. I question whether a general exclusion should be interpreted in that way when you already have a judgment saying this can be patented, and maybe that'll lead to a further reference. The third point he makes, which I particularly like, is he says, and I'll just read you this, it is disappointing that no further clarification was given with regard to stem cells created through somatic cell nuclear transfer. After all, the CJU might also have misunderstood particular details of those techniques. Probably right. But anyway, that's where we've got to. Now, I said in my provisional view, which I expressed in my judgment, was, I said, it's right that pluripotent cells should be the subject of patentability, totipotent cells shouldn't be. I don't really believe that. What I was really saying was that if you look at the directive, that's what it seems to be saying. In fact, as science moves on, and I was asking Pete before I met you, is it likely that totipotent cells may be the subject of stem cell research in the future? To which the answer, I think, is yes, it is. At which point we need to think, well, maybe this legislation needs changing. I mean, why a cell on a dish? Why would you not allow research in such an important field, which has so much potential to cure disease, to have the encouragement of patentability?
Thank you, Henry. My own mad inventor story was a chap who had invented some sort of motor car which would fly in the air and would operate without any energy source. And he'd been refused by the patent office, and he had an appeal coming before me. He never showed up. And the man who runs the law courts building said, pity, he said, I reserved a car parking space for him. Just so as you know, I'm a member of something called the Expert Committee, advising the European Commission on its required review of the working of the Biotech Directive, which is about 5 years late. Nothing is more depressing than being on this committee. The people chosen were chosen on a basis I know not what. I think to represent all views. For example, we have a gentleman from the No Patents for Seeds group of Germany. And people with very, very strong views one way or the other, but no, absolutely nobody who seems to know much about the patent system. There's a couple of patent attorneys, but even they know less about the patent system than I think they ought to. So there's your Europe for you. Sometimes I say to my friends, well, perhaps we should, we, the UK, should leave Europe, and then they all look horrified, and I say, and you should too, and we should start again, and then they agree. Lionel has kindly agreed to do the huge sweep-up of ethics and all other IP rights.
We've been talking generally about morality in relation to patents, where there is a specific provision, as Henry just outlined, that relates to various industrial and commercial uses of embryos. And then there's this more general provision that excludes from patentability inventions, the exploitation of which would be contrary to public policy or morality. And there are parallel exclusions from protection of various sorts in the other intellectual property regimes. And I think Robin thought it would be a good idea for me to talk about these. And as we'll probably discover in the next 5 or 10 minutes, he might be wrong. So firstly, in relation to
It's always a first time.
Firstly, in relation to trademarks, under the Community Trademark Regulation, the Trademark Directive, and embodied in the UK Trademark Act, you cannot register trademarks which are contrary to public policy or accepted principles or morality. In relation to registered designs, under the Community Design Regulation, Design Directive, and in turn the Registered Designs Act, design rights do not subsist in designs which are contrary to public policy or accepted principles of morality. So the same language, but in relation to trademarks, you just can't register the trademarks. In relation to registered designs, in relation to designs, which also includes community unregistered designs, the rule is that design right does not subsist in such designs. In relation to copyright, which is much less harmonised, the British courts had operated with similar sorts of exclusions from copyright protection, now usually thought of as situations in which the court will not enforce the copyright, rather than situations in which copyright does not subsist, and which in Hyde Park and Yelland, Lord Justice Aldous set out the various grounds. There would be no copyright in a work which was immoral, scandalous, or contrary to family life. There would be no copyright in a work which was injurious to public life, public health or safety, or the administration of justice. and no copyright protection for work that incited or encouraged others to act in a way that was injurious to public life, public health, or the administration of justice. And it seems that that copyright jurisprudence was imported into the law of confidential information by Vice-Chancellor Brown-Wilkinson in Stevens and Avery, though there he referred purely to the exclusion from the protection of confidentiality for matters which have a grossly immoral tendency. The former exclusion from protection of things that are illegal, tending now to be incorporated in the Public Interest Balancing Act, the act of balancing between the public interest in enforcing confidence against the public interest in disclosure in any particular case. So this just highlights to you that in all the other areas of IP there are parallel exclusions from protection of in various forms that relate essentially to the same two themes: IP, which is contrary to public policy, and IP, which is contrary to principles of morality. Now, there are various frequent factual scenarios, and here, I'm afraid, things are going to get a bit more fruity than they were in relation to the first slide. So, typical factual scenarios that have come before the courts are where marks, designs, works, or informations are vulgar. So, for example, FC UK regarded as capable of being a trademark, Screw You regarded as capable of being a trademark for sex toys and condoms, but not for T-shirts, Motherfucker, an inappropriate assigned to be a trademark for brandy in a general court decision. Secondly, there are cases concerning marks, designs, works, or information that have a sexual connotation or content. Masterman, I almost said that wrong. Masterman being a case concerning a Highlander doll with genitals, held to be registrable as a design by Mr Justice Aldous. Tiny Penis, in contrast, held contrary to morality or accepted principles, contrary to public policy or accepted principles of morality by Simon Thorley on the grounds that we needed to preserve the term penis to talk to our children about. Simon's not here, so I leave you the possibility of contacting him separately to explain that comment. Thirdly, we have situations where marks, designs, works, or information are politically offensive. There was a general court decision concerning an attempt to get a trademark that included the hammer and sickle, which was regarded in Hungary as a symbol of despotism and therefore inappropriate to be a trademark from a Hungarian point of view. The guidelines for the community design regulation talk about swastikas on textiles being inappropriate as politically offensive, and the OHIM, I think, rejected bin Laden as inappropriate to be the subject matter of a trademark. Fourthly, there are intellectual property subject matters potentially that have racist connotations. We had a general court decision a couple of years ago in which the UK intervened, where a German firm was trying to register the term Paki in relation to pallets, held by the general court contrary to morality as very racially offensive. And there are various US cases, most notably the one concerning the Washington Redskins, which the Board of Appeal of their trademark office has held to be not appropriate subject matter for trademark. And also one that I'll come back to in a moment concerning the rock band The Slants. There are situations where the subject matter has a religious connotation or is blasphemous, and that makes it contrary to public policy or morality. Jesus for trademark, attempt to register Jesus as a trademark was rejected by the appointed person, Geoffrey Hobbs. And there are situations where the subject matter promotes violence or some other illegal activity. Some of these are just examples given in guidelines or in case law. Lord Justice Alders said that a plan to rob a bank written out would not be appropriate subject matter of copyright or would not be an enforceable copyright in the Hyde Park and Yellen case. And the designs guidelines say a design for a landmine would not be a community design in which there would be no rights in the community design for such a thing. And intercity firm was rejected as a potential trademark. So those are the kinds of situation in which these things get considered, and they're quite different, I think, from the sorts of circumstances we're concerned with in Brüstle and the stem cell cases, and indeed the other morality cases in patents, which concern things like genetically modified organisms. How are these things decided? Well, here the case law is anything but consistent. We see sometimes an appeal being made to the point of view of the consumer, the average consumer being the normal figure for deciding issues in trademarks. But those are really the exception. There are many more cases that refer to this as being decided by reference to either a section of the public, as in the tiny penis case, or the public in general. The public in general is often thought to be important in relation to trademarks because it's not just the purchaser who might be offended or have their principles affected, but anybody who sees or comes into contact with the mark after sale. So we have a sort of concept of post-sale offensiveness of trademarks that's taken into account by the courts. So they look at how the public would react. Occasionally, where the goods are going to be sold and consumed by a particularly narrow audience, for example, sex toys that are purchased in sex shops and used by adults who are interested in those sex toys, then the court will be confident, or the tribunal may be confident, that the general public is not going to encounter words such as screw you, and therefore the test is not done by reference to the general public, but by reference to those specific consumers. In copyright law, the courts have tended not to concern themselves with this kind of question, though we don't have many cases on copyright and immorality. In the case in 1916, Glynn and Western Features, the court talked about the grossly immoral tendency of the work, which advocated free love, and it took it on itself to make the decision. And in Stevens and Avery, Vice-Chancellor Brown Wilkinson, in the context of confidence, said something will only really be contrary to morality where there's a generally accepted code, but regarding it really as a question just for the court to deal with. So that's the viewpoint from which it's judged. In relation to the community rights or the EU-wide rights, it's recognised that something may be offensive in some parts of Europe but not others. And usually in relation to those rights, therefore, a community right will be refused if the mark or design was offensive in any part of the community. The applicant then would be able to get national rights in the parts of the community where the design or mark was inoffensive. What are the characteristics of the public or the consumer? Well, in some cases, they're regarded as the average consumer. The Kuchatek case concerning the symbols of despotism talks about the average consumer. In other cases, we see a concern not to allow any old consumers' views in. So the only relevant consumers might be regarded as right-thinking consumers. That was the approach taken in relation to UK-registered designs in Masterman. Or consumers of normal sensitivity and tolerance. That was the view that the test espoused in the Paki case and the motherfucker case, which was a Spanish word that I can't pronounce, so I'm calling it the motherfucker case. And a number of these cases, I have to say, are motherfuckers because they're not in English. Oh, sorry, that was inappropriate. Okay, so what's the test? Well, sometimes we see the courts or tribunals talking about causing upset. Sometimes we see them talking about offence to moral principles. Sometimes we see them talking about something being seriously troubling, sometimes very offensive, and in the UK, most commonly, outrage, likely to cause outrage. Probably, it depends. In some cases, it might be that you have very wide offence of a low level, and the mark or design would be rejected. In other cases, you might have a lot of offence, but of a small section. So in the tiny penis case, Simon Thorley recognised that there might be a trade-off between these things. And that might explain why the case law is a bit slippery as regards the relevant audience from which the test is to be decided, and also the level of offence that has to be shown. In addition, not all the cases depend on offence. Sometimes the question is whether the sign or design just undermines certain values, and in those cases the court seems rather like in the copyright cases just to draw a conclusion itself. So that's those cases. Now I want to just raise two quick points. So the first is, how does all this fit with freedom of expression? So this is a big difference between these areas and patents. Patents on the whole don't raise issues of freedom of expression, whereas trademarks, designs to a certain extent, copyright, might well raise questions of freedom of expression. And in the United States, there is ongoing challenge to some of the decisions of the Trademark Office to exclude racially derogatory slurs from trademarkability, from being registered trademarks, on the grounds that by so doing they infringe the First Amendment, the US principle of freedom of expression. And there's one case called In Re Shao Tam, which concerns a band called The Slants. They call themselves The Slants. And they tried to register The Slants as a trademark. The Trademark Office refused that, as did the Trademark Board of Appeal, on the grounds that this was racially offensive. Now, this was a case where some Asian American people were trying to reclaim this hitherto offensive term. So it's a term clearly that if I used it, it would be offensive, just like if Jeremy Clarkson used it, it is offensive. But if people who are Asian or of Asian background want to use it and try and reclaim it for themselves, we can see there is at least some merit in them being able to choose whatever term they want and to reclaim whatever term they want. So this case has gone up to the Court of Appeal for the Federal Circuit, and the argument is that this exclusion, this refusal to register, is contrary to the First Amendment because it involves privileging some kinds of speech over others, and that is an inappropriate thing for the law of trademarks to do. So the question arises, how would freedom of expression arguments play out here, or how do they play out here in relation to the situations I've been talking about? And in general, I would say the EU tribunals have regarded the freedom of expression principles as having minimal impact on the trademark registrability. There have been cases that have gone up to the General Court, including the motherfucker case, in which the General Court has just simply said that the freedom of expression issue does not really arise. And the reason why they say it doesn't arise is because not having a trademark registered, not having a registered design, and also by extension presumably not having a copyright, doesn't prevent you from making and selling and using goods bearing those marks or designs. So your capacity to express yourself is not limited, and so all that happens is that you are denied the assistance of registration to enable you to promote your sign, design, or work. In some other cases, to the extent to which the courts have dealt with it, they have sometimes said, well, that it might be a justified restriction. So there's a general principle in Article 10 of the European Convention that there is freedom of expression, but in Article 10.2 there are a bunch of public policy grounds on which one can derogate from freedom of expression, and the requirements are that those public policies reflect a pressing social need and are proportionate, the way in which they're the way in which freedom of expression is proportionate to achieve those ends. In contrast, in the UK, freedom of expression has received a bit more attention, particularly in the Jesus case, in the decision of Geoffrey Hobbs QC. And he said it is important to interpret the exclusions with Article 10 in mind. And what I think is significant here is that the goals of refusing trademark protection must accord with the goals of Article 10.2. They must be legitimate public policy goals. And the mechanism of refusing trademark protection must be proportionate to those goals. And if that's the case, then the refusal of trademark protection might in fact be the most appropriate way, rather than banning the thing. Instead, refusing a trademark or refusing a registered design might be a more proportionate way to achieve the goal of registering that these things are regarded as obscene or offensive or whatever. On the other hand, this freedom of expression objection seems to me to be more of a concern in relation to the exclusion of copyright works from protection on the grounds that they are immoral. That seems to me to be something that is a bigger concern than with trademarks, but is one that hasn't been explored in any of the case law. So I have one more point, which relates to international intellectual property law. And that is, if we look at these different rules on exclusion from protection that trademarks, designs, copyright are subject to because they're contrary to public policy or accepted principles of morality, we can see that in relation to trademarks, this is explicitly authorised in the international treaties. So in the Paris Convention, Article 6, Quinquis B3, specifies this as a ground on which national trademark offices may refuse applications that derive from applications in other countries under the Tel-Cal principle. And Article 15.2 carries that over into the TRIPS regime as a possible ground of refusing registration of trademarks. So it's specifically recognised there. In contrast, there's no mention of this in relation to designs at an international law level. So Article 25 of TRIPS says nothing about the legitimacy of a limitation that the design is contrary to morality or public policy. And in relation to copyright, there is also no specific reference. People have sometimes suggested that Article 17 of Berne allows for this, because Article 17 of Berne allows contracting parties to control or prohibit by legislation or regulation the circulation, presentation or exhibition of works, i.e. it allows member states to keep their obscenity and censorship laws. But in the US and China decision, in which Chinese law said that works that are prohibited from publication by law shall not be protected by copyright, that was the Article 4 of the Chinese law at the time, the dispute panel at the WTO found this to be incompatible with the obligations to protect copyright under the Berne Convention and TRIPS, And Article 17 could not save it, could not save them, because censorship and denial of copyright are two different things. Now, the effect of that, therefore, must be to cast doubt on the legitimacy of public policy and morality exclusions from protectability of copyright works. And that's my final point. I can round it off by saying I see very few interconnections between this and the patent stuff, apart from at the most formal level.
Thank you very much. Well then, it's your turn. Anybody, any questions? Yes.
Very specific question.
Do you want a mic? And say who you are so everybody knows. I mean, I know who you are, but they...
Tim Roberts, patent attorney. A very specific question for you, Sir Robin. Couldn't you find anybody who come along and support the decision of the Court of Justice in Brüstle?
No, I don't think you can in this country. Does anybody here support the decision in Brüssel? Does anybody think it's wrong? Anybody who's neutral about it? Well, is this unanimous? Everybody thinks the damn thing was wrong?
Yeah, how widely did you look? Never mind.
I didn't look at all. I just invited people to come.
Yeah,
You
see.
support it?
Well, I think it's a pity, but there we are. I would like to make 2 points. You had a strong argument that this decision was wrong, and we haven't heard anything in favour of it. But it seems to be based on the view that it's inconvenient, which I can readily understand that it is inconvenient, that it would be much nicer if we could much more convenient if we could patent all these things and not. But the fact of the matter is that being legal in the EU or anywhere else doesn't normally correspond with being patentable. And that I would say that the decision of the court in Brüstle was a perfectly reasonable interpretation of the wording of Article 6. Now, it may be inconvenient. Furthermore, it would be good if there is a view that it is not the business of Supreme Courts, whether the US Supreme Court or the EU Court, to correct the errors of the legislature or to legislate. The fact of the matter is that the European Parliament produced this document, and it quite possibly wasn't perfect, it quite possibly ought to be amended, but the decision on the wording of the section was reasonable, and I find it difficult to see how you could go against it. But however, also I'd point out that it is somewhat temporary, because it now appears that the European Patent Office is prepared to allow applications relating to stem cells, provided the stem cells can be used without destroying a human embryo.
Yeah, they are. I'm bound to say, since you challenged me, I can't imagine for a moment how, particularly as a patent attorney, you thought that the decision was a reasonable interpretation of the directive. The directive says you can't patent the use of a stem cell. Well, the patent wasn't for the use of a stem cell. The claim didn't never mentioned a stem cell. What Pete's doing has got nothing to do. The patents he would have had would never mention a stem cell.
No, but
it's downstream. There is nothing in patent law. It's a perverse use of patent law to say that something which is covered by the patent claim is wrong because of something that happened upstream. Patent law, you look at the claim. And once you stop doing that, as they keep doing in the Court of Justice, you end up, same in Monsanto, with a perversion of patent law which is extremely dangerous in my opinion.
Well, Tim, I'm very glad you said that, because I did raise, when we met at 5 o'clock, isn't it going to be a bit boring if everybody thinks in the same way and nobody at all supports Brüstle. So I'm glad you do. I think the difficulty with Brüstle is that what they were trying to say was, let's draw the line between cells which are capable of leading to human life and those which aren't. And they just made a factual error. That's the real... Now, you might say that interpretation was too liberal, but that is what they were trying to say, and they just got it wrong. That was the...
I'm very willing to believe that they got it wrong about parthenoids. I am less willing to believe that they got it wrong about embryos.
Yeah. Question over here.
Barbara Laurie at King's College London. I think I have a bit of an addendum to Lionel's talk. I was just thinking about the enforcement of copyright in cases where there has been unethical behavior. So actually the copyright infringement is really more about stopping the unethical behavior rather than protecting the economic rights of the holder. So revenge porn cases, for example, or even the Google and Garcia case where you're dealing with trying to use copyright to protect the in a sense, the personal rights of the actor in that case.
There are also, I didn't really get a chance in the limited time available to talk about the situations where copyright is regarded as not enforceable or existing, depending on which view you take, because of the circumstances in which the work was created rather than the way in which it's subsequently being used, like the Spycatcher case, which really regenerated interest in this whole question, which had long been thought to be rather dead, whether immoral works were unprotected. Yeah.
We used to have the towels in the loos in chambers done by Initial Services. And there was a case years ago where Mr Putterill of Initial Services had gone off and told the competition authorities about what wicked things Initial Services were up to. And they sued him for breach of confidence, and he lost, but he'd been sacked. And some wit in chambers wrote on the Initial Services, reinstate Putterill, okay. Yes, Stephen. This is Stephen Jones, by the way.
I just had a quick follow-up to that last question. And if you're looking at the enforceability of copyright, are you looking at whether the words that are written down are immoral? For example, the robbing a bank example, or if you had a manual for terrorism or something like that. Or are you looking at something else like the person who wrote it? I'm thinking of recently in Germany, copyright was upheld in Goebbels' diaries. And I was a little bit surprised when I saw that. I mean, obviously the estate, he's got descendants who, these things have been published and so forth. But do you look sometimes at the nature of the person who's writing? I mean, I don't know what Goebbels' diaries contain because I read them. It may be just about, I don't know, his everyday life and his dog and his cat and whatever. It might, but are you looking at the substance of what's written, or are you looking at something else?
So the clearest cases look at the substance of what's written, whether it's this body of case law goes back to the early 19th century and considers whether the works were blasphemous or libelous or seditious. So it's the quality, and then the moral quality that relates to the work itself and its content. But then it sometimes does get extended further. So the example of the plan to rob a bank is, I think, an example of a situation where it's thought that would be contrary to public policy to enforce copyright in such a case.
Why would it be contrary to public? So you can't stop anybody copying it, so everybody can copy it and everybody can learn how to rob a bank. I mean, it's completely cockeyed reasoning, isn't it?
Would you say, in other words, does it depend on what Goebbels wrote, or should he be denied copyright because he's Goebbels?
So certainly, it's easier if it's what he wrote. It's difficult to find a plausible argument that he should not get copyright because he was Goebbels.
Do you know, it's interesting. When I was listening to Lionel, I was thinking, is it all just so ridiculous? I mean, these cases are generally laughable when you hear about them. And actually, if you get the chance, Tiny Penis is a gem and well worth reading. But I guess that the only saving grace, small gem, the real saving grace is perhaps that as morality changes, inherently changes public morality, maybe it's a provision that is worth keeping, that can adapt with the times and is perhaps becomes limited to cases which people would now find offensive, such as perhaps, Hitler, Goebbels type publications.
Yeah, there's a question over there.
This is just a follow-up to what Stephen was saying. So Rowan, Freeland, Simmons. I'd understood that the reason why they wanted to give copyright protection to things like Goebbels' diaries, Mein Kampf, and such like, is so that, as Robin suggested earlier, so that you can prevent publication and keep these things in the security of libraries where neo-Nazis don't like to go.
Yeah.
And I thought a plan to rob a bank was a business method and unpatentable.
Dominic Hughes, 3 New Square. I was just wondering, do you think there's a danger that whenever people discuss issues of morality or morality or ethics in IP, it's nearly always by reference to these specific exclusions, whether it's exclusions of patentability or trademarks or copyright? And the thing that strikes me is nearly every week I see IP owners who ask me, as a practicing barrister, to do all kinds of unethical, immoral things. Like, if I give an example, I hear nearly every week, we know the other side haven't got much money, we know our IP right isn't very good, but they'll fold if we sue them. Now, that strikes me that if we just think of morality and ethics in terms of these small categories for patentability, there is a danger that the profession begins to shut its mind that lots of other issues to deal with IP rights, so how you threaten people if you've got a not very good IP right and they're poorer, or how prepared you are to lean on witnesses to say things that it's a one-sided story. I think if we get very focused on the exclusions, we can lose some of that. Does the panel have a comment on that?
Well, it's a very interesting point, Dominic. I mean, one way of looking at it, that as a lawyer, barrister or solicitor, your duty is within the ethical code to represent the interests of your client, which is very important duty. Everybody needs their own champion. Now, there are many things, and I think it's quite a strict ethical duty, your duty to the court. There are many things you mustn't do. I mean, the classic example being not withholding disclosure that's inconvenient to your case. On the other hand, if you raise questions like it is immoral and ethical to think, well, we'll pursue this case because the other side don't have the money and are going to fold. I mean, I suppose you might say that's immoral, but it's certainly, as we all know, within the rules, and if you didn't do it, maybe you wouldn't be representing the interests of your clients properly.
I think actually it's a different question. I mean, it's a bit like saying, is underarm bowling cheating? Even by Australians. And the answer is within the rules. And if you're playing the law, it's within the rules. We don't have, it's not cricket in the law. Yeah.
Roman Choli. I'm a trademark attorney. I'm also a research associate at the Von Hugo Institute, St Edmunds College, Cambridge University. This isn't so much a question as a point of information. Just very recently, we held a 2-day international interdisciplinary conference to which 1 or 2 on the panel were invited who weren't able to attend, at which we discussed issues of IP and ethics. The focus was on patenting living organisms, and the Brüstle case was actually discussed very vigorously. And I do want to say, referring back to 3 questions ago to Tim Roberts, that actually there were some very intelligent, very articulate and eminent people who spoke for the other view. So we had both sides.
Matter of interest, were they Brits?
Yes, yeah. We had, well, one wasn't a political scientist, Professor Ingrid Schneider, but we had Professor Albert Jones, who's a well-known ethicist here. And the point of this intervention, or this point of this point, is just to announce that we hope to have a publication which will continue this. Well, one of the themes would be continuing this discussion of Brüstle on with both sides of the argument. We also discussed at this conference, and we hope to develop the theme at our centre at Cambridge, issues of social justice and IP, and international development issues and IP. Thank you.